case 232644. Counsel for Ms. Epps. Whenever you're ready, you may come to the podium and let us know how much you want in terms of rebuttal time.
Yes, Your Honor. Good morning, Christopher Klemowish. On behalf of Ms. Epps, if I could, I'd like to reserve 5 minutes.
Okay, thank you.
May it please the Court, Your Honors. I want to start from the fact that Ms. Epps was injured in a head-on collision caused by a drunk driver, for which appellee Tricia Morrow was sentenced for years in the Department of Corrections in prison. And that's the genesis of this case. The main points I want to bring up are the trial court did not follow this court's legal standard for addressing the motion to dismiss for fraud. Number two, the appellees have not and cannot prove by clear and convincing evidence either that Ms. Epps knowingly and intentionally engaged in a scheme designed to thwart justice, nor have they proved by clear and convincing evidence that they were in any way hampered or prevented from presenting a defense to this case. Number three, the record below and here shows that Ms. Epps was entitled to prevail on certain issues, or that the appellees below in the trial court did not even challenge certain injuries, but that the trial court, in an unfortunate baby with the bathwater approach, threw out and deprived Ms. Epps of the right to present to a jury.
What damages were not contested?
That's a good question. One of the injuries that the appellees did not contest at all in the trial court was an injury to her right wrist. That was an injury that was a sequelae of her having lower back surgery and resulted in her having neurological issues in her wrist from leaning on her walker, her support. She ended up having surgery for that, and that was something that was never addressed at any point in any of the motions below.
In terms of when they stipulated the punitive damages being recoverable and stipulated or announced that they were admitting liability, in both of those documents they said the defendant maintains all the defenses to the case, including all defenses regarding causation of damages.
Right.
So how is that a stipulation that the wrist injury was not fraud?
I'm not saying they stipulated that the wrist injury existed. And the stipulation I think Your Honor is asking about, there's a question of what were the injuries versus what. I want to be clear, I'm not saying they stipulated any injuries. I'm not saying that at all. What I'm saying
How is she entitled to recover it then? I mean, you acted in your brief almost like you were entitled to a DV as to certain injuries or medical expenses related to certain injuries. I think this is different than the Jimenez case, where there was no issue presented as to the medical expenses or I think the guy's truck. Whereas here, they contested all issues of their I'm assuming they didn't contest the property damage to the car, because she admitted fault for the accident. But in terms of all causation and damages, I take that to mean personal injuries. All injuries they contest.
Yes, and I think they're slightly different issues. Part of my point was the wrist injury, for example, was not even something that was raised as a fraud basis below, but the court threw it out anyway, along with the things that were, and that was my point there. As to Your Honor's question about which were uncontested and why we were saying they're entitled to judgment, the reason we point that out is because defense for the trial court hired their own CME doctor, Dr. Shim. Dr. Shim conceded that this crash caused injuries. It caused her neck and back pain, by which he meant injuries to ligaments, tendons, things like that. Dr. Shim conceded that medical treatment was reasonable and appropriate for those injuries that were caused by this crash. Emergency room services, emergency room evaluation, medical evaluation, physiatry evaluation, MRIs of her lumbar and cervical spine, chiropractic treatment for up to 3 months. So while they're maintaining their defenses, their own witness is saying this person was injured. Okay, this crash caused this person injuries, and at that point, you can't dispute that's what happened. Nobody's going to come in and say anything different.
Right, but the law says if your client committed fraud in the court, it's not entitled to rely on the court even for those damages.
Well, then I think we have to get to the idea of fraud, which we're not agreeing on. I think our point is in the scheme of this, not scheme, in the broader umbrella of how these things are presented to the trial court, there were too many issues in Ms. Epps' favor that could have or would have ultimately benefited her in front of the jury, or as a matter of law, for the trial court to simply say, no, I think you lied, everything is gone. And that's the point we're trying to get across. There were too many things that, especially if the defense's own expert is saying this crash injured her and she should have gone to the doctor for that. To throw that out was not proper.
No, I understand where the distinction is.
That's the issue of fraud. How many social security disability claims had your client made prior to the accident?
I don't know the answer to that. I don't know if it was one claim that was renewed over time or
More than one, wasn't it?
candidly, Your Honor, I don't know.
When did she disclose that?
She disclosed that in her initial amended interrogatory before her deposition was taken, that she had applied for Social Security.
So is the answer brief correct in the second supplement to your interrogatory answers that your client disclosed 16 new medical providers? I counted 16. I just was curious why you wait so long in the litigation to disclose 16 new medical providers.
So in that amended interrogatory answer, yes, she did disclose multiple doctors.
I mean, 16, that's a lot, right?
It is a lot, and it owes to probably the most complex prior medical history I've had in a client. Thousands and thousands and thousands of pages. She had hysterectomies. She was repeatedly admitted to the emergency room for kidney stones. She had endometriosis. She had just innumerable medical issues that she was constantly seeking medical care for.
The accident was in January of 2020, correct?
Yes, Your Honor.
And as of December 2019, she was still getting treatment, medical treatment for her neck and back injuries, correct? Neck and back pain, correct?
I'm sorry, what was the date?
December of 2019.
For neck pain, yes, Your Honor.
Yeah, but she denied having any treatment for neck problems or pain in her interrogatory answers, supplemental interrogatory answers, in her deposition, didn't she?
I believe in her answer in deposition and I would have to check which interrogatory, but I believe in deposition she said she had whiplash in the June 2019 tubing incident that caused her that pain.
She denied any treatment for that. So.
I believe she did say that, yes, Your Honor.
Well, we're not going back to, she remembered falling out of a tree when she was 12 and breaking her wrist, and at the ice rink she got her 2 or 3 other things, and she remembered other things in recent history. So it's not like she's got 10 years of blank time, or the defendant's going back to when she was 5 years old and got her. This is treatment for a neck pain, and she's claiming neck pain from this accident. Treating in December of 2019, the accident's in January of 2020, the suit's filed in May of 2020, right?
Sure.
I mean, so this is stuff close in time, so you could see where the judge would listen to the defense and go, something smells fishy, not that it is, but yes, I want to hear about this, I want to know about this, because this is not just, this is not going way back in time, you forgot about that knee injury you got 10 years ago.
Right. And I think there are a couple things here. One is, and this is where language is very important. One of the things that the argument was raised below and in the briefing here, the appellees say things like past history of injuries identical to those claimed in this litigation. Well, that's not true. And this is one of these reasons why trier of fact needs to resolve these things. What the records actually show, and this is at record page 1538, is Ms. Epps had what was diagnosed as a mild bulge in the disc at C6, C7 before this crash. What the records then show after the crash was a disc bulge at C5, C6, which is an entirely separate area of her cervical spine, as well as a possible superimposed disc protrusion, which is a more advanced form, in other words, a herniation at C6-7. So not the identical injury, and yet that's the argument that the defense below and the appellees here are presenting, which is just simply not accurate. The other issue that we have concerns with is Ms. Epps was diagnosed not by one, but multiple doctors and an expert with a traumatic brain injury from this crash. And I mean, I have had multiple clients that have had this. It's a sad thing to watch, but they do the same thing Ms. Epps is faulted for here. They get confused, they forget things, they say wrong information. It happens all the time. You have the same conversation with them, and they react totally differently, or at least I didn't say that.
That may be true, but in terms of what evidence was offered here, you had your expert saying she has a TBI, you had the defense expert saying she was malignant, right?
That's right, and that's another reason why I think it's not clear and convincing evidence of fraud. I think that's an excellent point. It's not all one-sided. What this court says is, and this is our concern from the get-go in terms of how the trial court handled this, is that this is an extraordinary remedy to dismiss outright for fraud. And even inconsistency, non-disclosure, poor recollection, dissemblance, and even lying is insufficient to support the dismissal for fraud. And in many cases may be well managed and best resolved by bringing the issue to the jury's attention for cross-examination of the appropriate remedy. I think that's exactly what it was. And I think that gets into...
Just leave it under cross-examination.
Yes. I mean, I think it's a question of trier of fact. And that's... I see my initial time is going to be running short, but that's part of the concern here is the volume of both past pre-crash and medical injuries from this crash are so voluminous that it's not the kind of thing that it could just be dismissed and say, well, that because you had certain things before, you were lying about this case. It's not.
She said she had no treatment for neck injuries in her first answers to interrogatories and in her deposition, correct?
She did say that.
Well, again, we're talking about December 2019, January 2020, May is when the suit was filed. I don't recall exactly when her deposition was taken, but it was taken pretty quickly, I think within a year. So, again.
Yes.
I was a trial lawyer. I understand people forget things. Sometimes you get excited when they do. Sometimes, you figure out it's just that long ago. She made, according to what we can see, 3 or 4 Social Security claims for disability. She claimed that she made one for endometriosis. And in fact, she made others claiming she had fibromyalgia, she had low back pain, this pain, that pain, all of which kind of comes down to say, if you get caught at it, okay, you got to do the dance on the rug and admit you lied, and you still get a chance to recover. And there's other cases that if it rises to the extent of fraud, then no, you're out of court. And
right.
That's what we're trying to deal with, and that's what the trial judge is trying to deal with.
I agree, and I'm glad you brought up the Social Security records, because this is one of the things that below, and again in the briefing, the appellees keep saying, she applied for Social Security. They desperately want it to be neck pain and back pain. Those records do not say that, Your Honor. You can look at the record, page 1133 and 1137. They list 10 conditions: endometriosis, MVP, heart condition, anxiety, depression, lupus, fibromyalgia, polycystic ovarian syndrome, chronic migraines, chronic kidney stones, and chronic pain. Not one of those things.
Wasn't lumbago mentioned in one of the reports? One of the applications, which is low back pain?
It was listed in there, but that was not listed as a reason for what she was actually applying for. I mean, you can have that as a
But it was in the Social Security records that she had complained about,
it was in there that she complained of it.
which she denied having any complaints with low back pain. Up to a certain point, and then she said, yes, I did. Right?
I would have to check exactly the record, but
You're into your other time. If you want to keep going, it's your time, or you can come back. Whatever, it's totally up to you.
yeah, I would like to make one point, if it's okay, and then reserve the remainder. If we concede, if the conclusion from the court, or if we concede, you know what, she lied, the standard still has to be not just that, but that the defense below was prevented from defending their case. By clear and convincing evidence, and there is no possible view of this case that happened. They had every opportunity to explore this. They had no stone was left unturned. They had all of the evidence at their disposal. And I think one of the interesting things was this case went to non-binding arbitration 2 months before it was scheduled to go to trial. They had the same evidence then. They didn't ask for a continuance. They didn't say, hold on, we're not prepared to do this arbitration because we can't defend this because of all that. They didn't do any of that. They never went back and redeposed her. They never submitted additional discovery to her. And so to say, well, hold on, we were prejudiced in our defense, that's not what happened. They had their whole defense ready to go, and then after the non-binding arbitration that they agreed to participate in, then they said, well, hold on, this is bad.
Non-binding arbitration can be a good tool to get a settlement of the case, correct?
Potentially.
That's the whole idea. Maybe settle it based on the arbitrator's decision. It didn't settle, so it went on to trial. Or, well, it would have gone on to trial, but otherwise.
Yes, sir.
All right, thank you. You've got 3 minutes.
Thank you.
Good morning, may it please the court. My name is Keisha Justice, and I represent the appellees Tricia Marie Marrow and her father, Robin John Marrow. And Your Honor, Chief Judge Edwards, you brought up a great point in the Jimenez case, talking about when is it appropriate to dismiss a case for fraud on the court. It's in those extreme circumstances. And this court, in the Jimenez case, says the only way to discourage that type of fraud is to punish it. Because if it were left only to cross-examination by the trial, then what would be the means for a litigant to come forth of their own accord and truthfully disclose and truthfully answer questions pertinent to the litigation, the very core of the issues that the finder of fact is to decide.
What about in this case, there was certainly evidence, conflicting evidence, that she had a traumatic brain injury, which can cause memory loss, things of that nature. How do we deal with that?
Absolutely, Your Honor. So the cases actually discuss what happens when someone is claiming a traumatic brain injury or some other memory or cognitive issues. How does that come into play? This trial court addressed that as well. And here, the trial court relied upon those cases, and I can quickly refer you, Your Honors, to those cases. For example, in Ryan v. Mezzo, in the Di Stefano case, which affirms dismissals where misstatements went beyond present physical abilities into concrete historical facts, despite plaintiff's claim of memory problems. And so our trial court judge said, it's not just that she can't remember some things that are pertinent to her claim. She can't remember anything about her prior medical history. In fact, she doesn't say she can't even remember. She says she doesn't have any prior medical pain relating to her neck, back, or cognitive problems. And Judge Edwards, I believe you also brought out a question of, well, didn't Ms. Epps also say she can remember her childhood incidents of falling out of a tree, she could remember she fell one time when she was running in high heels, and even recalled that she went to go seek chiropractic treatment for that injured ankle as a result. She could recall in depth regarding all of her prior non-related neck, back, or cognitive problems regarding her endometriosis, regarding her kidney stones, and the surgeries that she's had related to that. So despite this very rich history that she gave in her deposition of all of her prior medical claims, what she said resolutely was not, I don't recall. I have memory problems and it's difficult for me to recollect. What she said under oath was, I never had any problems. I had some whiplash, I never treated for it. I had never had any neck or back problems. And the medical records that defense counsel in this case uncovered completely shows that that is false. And it does reach that level of fraud in a calculated scheme. And if you look through the entirety of this litigation, it wasn't so much that it was uncovered one medical record or two medical records. Instead, the course of the proceedings show that first defense counsel, they were able to uncover records by Dr. Kim. Now, it wasn't because that was disclosed in interrogatories or in her deposition. They found it through other means. So then they said, who is this Dr. Kim? And why is he treating her for neck problems? So they go and they subpoena those records. And then from those records, they find more medical records, undisclosed medical treating providers regarding her neck and back. And then once they recover those records, and so on and so forth, down the rabbit hole you go, you
Why
start
can't
coming
this all be
into...
cured through cross-examination as the appellate argues, rather than dismissing the action?
This can't be cured through cross-examination because it goes against the complete, it goes against the standard that such fraud, as to this level, there should be a punishment. And the reason why is if a party lies about matters directly on the issue of causation and damages, had defense counsel not been successful in uncovering those misrepresentations, it would have interfered with the jury's ability to adjudicate the central issues of causation and damages. One point I did want to bring up about causation and damages is that there's been argument that there's been stipulations regarding Dr. Shim, who is defense's CME expert, compulsory medical examination expert, for neck and back. And if you take a look at the records, those records show that Ms. Epps lied about her medical condition to Dr. Shim. And so she said to Dr. Shim in that CME exam, I never had any neck or back pain, and it would be a surprise to me if there was any sort of films or test or studies done that show that. And in his deposition, Dr. Shim says, I rely upon what the patient tells me. I take her at her word. So if Ms. Epps is permitted to argue that, well, they conceded there are some neck and back problems and some medical damages, it was only because she misrepresented that to Dr. Shim in the first place. And Dr. Shim said, I rely upon Ms. Epps to tell me the truth, which did not happen here.
It was kind of a catch-22, it seems to me. On the one hand, the defense knows a lot, but do you know everything yet or not? Who knows? But you know a lot, so you could go in and defend, and as Judge Boatwright suggested in counsel for a counsel, you could have a field day with Ms. Epps on the stand showing she lied about this and that, and this and that, and this and that. So where's the prejudice? You now know, supposedly or theoretically, all there is to know about her medical condition. So where's the prejudice, other than you had to do extra work?
Sure. So it was discussions about there was no hampering of the defense. Ultimately, through the diligent efforts of counsel was able to uncover, we still don't know maybe all of it, was able to uncover all of these misrepresentations as to every single element of Ms. Epps's claim. However, The Rainey Court, which is a second district court of appeal case, then Judge Kennedy issued that and said the misrepresentations themselves are the hampering of the case. Just those misrepresentations. So additional trial continuances, that's not the cure. And in fact, if there was such an argument, that would go against what's going to be coming down as new Supreme Court measurements to trial courts saying, we need you to keep these cases on track. The Cox Court, which is a 50CA, kind of the seminal case about fraud of the court, talks about that a system that depends on an adversary's ability to uncover falsehoods is doomed to fail. And that's the prejudice. And if counsel had not, through its own diligent efforts, uncovered those misrepresentations, they may never have been successful on this case. That's the prejudice. There's also been argument about this was brought after, this motion to dismiss for fraud was brought after arbitration. Your Honors, there's no timing on when a motion to dismiss for fraud shall be brought. The only case that discussed an improperly timed motion to dismiss for fraud was after a jury had already returned a verdict. That's not the case here. Additionally, there's, with regarding the arbitration, it was Ms. Epps, after getting that arbitration decision, who moved for a trial de novo. It wasn't the Marrows who moved for a trial de novo. So having not accepted the arbitration verdict, then this proceeded, and the Marrows filed their motion to dismiss. Are there any other questions from Your Honors?
No, thank you very much.
Thank you. And so respectively, the Marrows request that this court affirm the well-reasoned opinion issued by the trial court judge, and that based on the extensive fraud in this case, dismissal for fraud was appropriate. Thank you, Your Honors.
Whenever you're ready, counsel. Sir, you can find room for it.
I said, may I proceed?
Yes.
I said earlier, language is important and we need to be precise. This idea of back pain is one of these issues that's concerning. We can't just say, oh, she had back pain, and then just throw everything out because she had prior treatment for pain in her lower back. What she was asked in her deposition was, have you ever injured your low back before January of 2020? No. Have you ever had any low back pain or problems before January of 2020? Answer, the only pain I had before that was kidney stones, and that was like my upper kidneys, and that's close to my back. That's about it. That's what she said. She never denied low back pain, and I would defy anyone to go back through, again, thousands of pages of her medical records to find any traumatic back injury. And in fact, that's not what they show. The records that the appellees rely on themselves show that that's not the case. Look at on page 18 of their brief, the appellee cites Dr. Otero from all the way back in 2012. Those records show Ms. Epps was atraumatic, in other words, no traumatic back injury. You then go to Dr. Benny from 2018, record pages 1586 to 1597. Repeatedly, absence of any prior trauma. Not only that, but the treatment plans for fibromyalgia, not a spine condition. And it goes on and on like that. So this idea that she lied about back pain is not only wrong, but it's a real gross overgeneralization, and it's not the kind of thing that should lead to someone's entire case being thrown out.
Do you agree that lumbago is a term describe low back pain?
It does describe that. And that's why I was trying to be so
Well, I
precise.
thought in her kidneys, when she was talking about that in her deposition, I thought she said that was in mid or upper back, not low back. Don't worry about it, we can look at it later, we don't have much time.
Yeah, my point there is all of her medical records in that issue show that it's related to a kidney issue. Wherever she describes it in her non-medical position, she says, I had low back pain related to kidneys. That's what the records show. So I don't think this is the kind of situation, as I said, even if the court concludes she lied, I don't think it's clear and convincing evidence, and I don't that there was any prejudice to the defense. And I do not agree. I'm sorry, I don't know over time. May I finish that thought?
Yes, go ahead.
This idea of diligent efforts, it all stems from Social Security. First of all, they didn't go after that for over 2 years, even though she told them she'd done it. Then she turned it over herself. It was not the diligent efforts of trial counsel. Ms. Epps, who didn't want her trial continued anymore, went to the Social Security office and got them the same day and handed them over and said, here's all my records, go through them. Okay? Again, they cannot prove there was prejudice, certainly not by clear and convincing evidence, and this court's guidance on these do not support the trial court's issue, so I would request respectfully that be reversed and sent back for trial.
Great. So your Stetson students are still hanging in here. If you would, introduce yourself as long as you're standing, and tell them where you went to law school and how it is you chose to become a lawyer.
I'm Christopher Clemens.